Commissioners Court, and especially before the holiday of Christmas. We thank you each for being here with us, and also remind you to please make sure your phones are silent and any conversations carry them outside, please. This morning we have Brother Brent Williams with us to lead us in our invocation, and Commissioner McCann, the pledges, please, sir.
Let's pray. Father, we thank you for everything you give us, but it is Christmas season. We have to realize that every good and perfect gift comes from you, from the Father of lights, and we just praise you for that. But the greatest gift that I think you can give us is you've told us not to worry about anything, but in everything with prayer, with supplication, with thanksgiving, to make our requests known to you, so that the peace of God, which transcends all understanding, would keep our hearts and minds in Christ. And I think the greatest gift you can give us is that peace of God. So I pray that over the court today, that during this Christmas season, they experience your peace. And it's in Jesus' name I pray. Amen.
Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I honor the Texas flag. I pledge allegiance to thee, Texas, one state, under God, one and indivisible.
Thank you, Brother Williams. Well, again, good morning and welcome. The time is 9:03. We do have a quorum, so we will call this meeting of Commissioners Court to order. Are there any citizens' comments?
No, sir.
Item number 1 is consider and take action on minutes of previous meeting of Henderson. Excuse me. Can I start again? Consider and take action on minutes of previous meeting of Commissioners Court held on December the 10th, 2024. Are there any additions, deletions, or comments?
Hearing none, Judge, I move we approve the minutes of the previous Commissioners Court meeting held on December the 10th, 2024 as presented.
I'll second the motion.
Motion made by Commissioner Tooley and seconded by Commissioner Spivey to approve the minutes of Commissioners Court held on December 10th, 2024 as presented. All those in favor of the opposed? Passes unanimously. Thank you. Item number 2 is consider and take action on a request for a refund of overpayment of taxes from the Henderson County Tax Assessor Collector. We do not have any today. Item 3 is consider and take action on change order number 2 for SCI construction for AgriLife and Senior Citizens Building as a part of the ARPA program. Ms. Vaughn?
Good morning, Court. This is for Package A and Package B for the construction. The first change of order is for $117,500, and the second for Package B is for $68,000.
With us also, we have Wesley Traylor. It's been a part of our ARPA program. This change order is to complete the obligation process involved with ARPA. Mr. Traylor, would you care to add to this discussion?
Good morning, Judge and Commissioners. As discussed in our most recent workshop, this is that change order number 2, and this is satisfactorily awarding the alternate items that were part of the original bid package.
Court, any questions concerning this? This makes us square and true on our obligation portion of ARPA with the audit office?
Yes.
Okay. All right. We're almost to the first finish line of the first phase of this.
That's right.
Process. We'll have our final phase on the 31st, December 31st. That will close out that first hurdle of ARPA. In that, anything you wish to share, Mr. Traylor?
No, Judge. Maybe we can just call that meeting obligation station. I don't know, but we'll be there. We'll be there. Thank you.
All right. Court, questions or comments? Any signatures required? Okay. Authorization of the judge's signature.
So moved to approve with the judge's authorization to sign.
I'll second the motion.
Motion made by Commissioner Richardson and second by Commissioner McCam to approve change order number 2 for SCI Construction for AgriLife and Senior Citizens Building, part of the ARPA program, with the county judge's authorization to sign. Any further discussion? All those in favor? Passes unanimously. Thank you both.
Thank you.
Item number 4 is consider and take action on order to establish an alternative dispute resolution system for Henderson County, Texas. And with us this morning, we have Mr. J.D. McMullen here to present the program and kind of enlighten us on it. Mr. McMullen.
Good morning. Good morning, everyone. It's an honor to be here with those that serve Henderson County, the capital of the Black Eyed Peas. I'm here, this is odd, I'm not here to solicit business. I'm here as an advocate of giving back to my community and as a mediator who is just an advocate of programs like this. My name is J.D. McMullen. I'm an attorney mediator in Longview. I've been those things for almost 20 years now. And I've been familiar with mediation and their systems as somebody who volunteers on a pro bono basis for that as well. But with that said, we're here today to talk about Chapter 135 of the Local Government Code. And ladies and gentlemen, up here we've got Section 1 is, these are the basics, all right? So that law came into effect in 22. Anytime you file a lawsuit in the JP Court, County Court, District Court, those filing fees have to be distributed amongst 14 different funds. They're allocated on a percentage basis. The only fund out of all of them is the County Dispute Resolution Fund that requires action to keep your county money. And so, what's the action? Well, it's as easy as today, when I finally shut up, y'all take a vote, and you enter this order officially establishing Henderson County's dispute resolution system. And I guess I should have started with what mediation is. Not everybody knows what it is. You got a neutral third party to try to help folks that are, going through the long process of lawsuits. I believe it's something that truly provides resolution in the community. Well, okay, JD, we order the establishment of this system. You get to start keeping your money. If you act before the end of the year, you get to keep the money that's currently in the fund. But then it's okay. Well, JD, it's going to give a bunch of work. It's going to cause us, work that's worth. If you turn to Section 3. You see all these different bullet points. It's kind of showing this is what everybody's responsibilities are as the clerks, as the treasurer, auditor, etc. The most important power of all of them is this Commissioner's Court. Under the Texas ADR Act, Chapter 152 of the Texas Civil Practice and Remedies Code, county commissioners' courts are the only ones that have the authority and discretion to order the establishment of the system. And once that system is established, y'all are the rule makers. How this system works and what do we do with this money? Well, your judges are going to kind of be your gatekeepers in this sense. They're going to decide, they ultimately would refer the cases down to the system. Okay, why is this important? Well, what I've learned is, some judges already have mediators they like to use. And some of them can be expensive. What I propose is, a lower rate of mediation cost, but judges want to be able to use their same mediator. That's fine. There's enough discretion where a judge can refer to, I'm not going to say buddy, but the mediator regular that he uses, and then send these other cases involving folks who can't barely afford a lawyer if they have one. Those are the cases that you can refer down to the system. And I know I jumped over Section 2, but Henderson County over the first 10 quarters starting in January 22, remitted a little over $80,000, which is the third highest in EdCog, but it could lead to an approximate yearly budget of around $35,000. And so, okay, what do we do first? Well, we have to save. So this is the easiest part. At a minimum, y'all need at least a year of saving, if not 2, if not 5 years. Because, you look at that, I mean, $32,000 a year is, I think, a lot of money. But to have an effective system, sufficient funding is necessary. So taking the time to save is absolutely necessary. And Chapter 135 of the Local Government Code says this money in this fund can only be used to establish and maintain the system, meaning that the statute right there envisions that they know at the moment of establishment that these systems aren't up and operating. Money has to be saved for this. There are big counties, all the big counties across the state have had these systems in place for years, and they have not had to report any of this money. The state is only tracking those counties that are giving its money back. I started looking into all this in September. I'm very familiar with the code, but I moved back up to Northeast Texas, and I looked into all of EdCog at Judge Stout and Judge Sims' encouragement, and I got all the numbers of what everybody up here had been doing, and I said, well, tell me how much money the counties that have established systems have been able to keep. And they're like, oh, you're going to have to go ask them. And I asked Harris County, because I used to volunteer down there, and they've been able to keep over $3.5 million. And so this is just more of an opportunity of finally smaller counties have access to money to have a system where people can resolve their disputes via mediation. The only thing that changes when it comes to, if you turn to the back of section 3, right before the green divider there, the only thing that changes on the quarterly civil filing fees report is line 10 becomes 0. So your treasurer is not having to calculate this stuff. It does not add extra reporting requirements. Since the ADR Act in 1987, there have been no reporting requirements of any county dispute resolution system. The Supreme Court of Texas has the authority to set reporting requirements, but none have been set. So it is the Wild West. I'm a big proponent of mediation and hope counties use this, but if you just want to keep county money and not send it to Austin, this is something you can do. The law, in 5 years, let's say y'all decide to save for 5 years. In 5 years, who knows, the legislature might change the law again to where, okay, that dispute resolution fund, it can be used for other things. And so it's also just, there's no way to close this loophole. It's literally like the state gave y'all a plumbing system and it had one leak. And it was just a matter of somebody coming in, public service announcement. Here's how you fix the leak. That's it. But why am I here? Well, I do have an offer in this sense of for each. So far, 9 counties of EdCog have established their system since Harrison County was the first one, October 8th. Gregg, Upshur, Rusk, Van Zant, Camp, Marion have all established their system. And all those green marked counties on that that chart that shows all the money. So far, the only ones left that have not are Wood, Smith, Panola, and Henderson. But I just haven't gotten over here yet. So it's not that y'all are the longest drive for me for Longview, so it took me a while to get over here. But if you establish the system before the end of the year, you get to keep your money that's currently in that fund, but it also triggers my pro bono advising guidance, whatever you want to call it, over the next year to figure out what system is best for Henderson County, in which, the section 4 of this proposal is just examples that, if anything, guarantee that due diligence is required to determine which system works best for Henderson County. Throughout the year, there'll be polling of judges to figure out which cases are clogging their courts. There'd be, polling of the Henderson County Bar Association. Getting everybody involved to figure out what works best for Henderson County. There had been, suggestions that EdCog, which I have no relationship with other than I'm going to their meetings, they could operate as an administrator of this system. But ultimately, that's up for the counties to decide. I don't care either way with that. What I care most about is what's best for Henderson County and establishing its own mediation system. And that's what that pledge, that's in that back part, that's that last section 5. But I'll be here to defend any action from the state, anything that is required, but more importantly, helping y'all figure out what to do next. And it could be, we're going to save for 10 years. And then you have to call me back up in 10 years and say, what do we do now? But thankfully, I've had the opportunity to discuss this with the county attorney, a very brilliant young man. Clint, would you mind? Do you see anything bad with this?
I smirked a little bit, I'm sorry.
Just had a birthday.
But it's,
I'll come up and join you, JD, but I guess first of all, what questions does the court have? Does the court have any?
Where does this money come from?
Fees that I'll answer, and then if I say something wrong, you help me out. So every case that is filed, you have court costs, fees that are paid in the front, and that's what JD mentioned. So there is now a statutory mediation fee that we currently collect on every civil case that is filed, whether it's filed in district court, county court, or those on JP courts also, JP court cases. And so there's a fee that's collected, and because we have not established an ADR system, that money is remitted to the state because we don't have an ADR program locally. So right now we're collecting those fees. That's where he mentioned, I believe the average is about $32,000 last year in fees that we sent to the state, that if we had our own dispute resolution program here, we could use those funds here.
And then, so we're collecting the fee already.
Yes. This is not adding any new fee. That's a
We're
good
sending
point.
every bit of it back to the state.
Yes, so this is
We don't
not
have any
adding
way
any
to
fees to
recover
the
any of it.
public that may be filing cases. We're not adding anything additional that we're not already collecting. The only thing we would be doing is, rather than us sending that money to Austin, we would be keeping it here locally to administer.
And then when we keep it here locally, what can we do with it?
We set up a plan, and that would be the next step. First, we have to create the fund, and we have to pass the resolution saying, yes, we're creating our own resolution system. Then Anne Marie and them would set up a separate fund in accounting. That money would stay here instead of sending to the state of Texas. And then that's what JD was saying is probably over the course of the next year, may not take that long, but you've got that long because you're going to want to have to build that fund up a little bit. And so over the course of, let's just say, the next year, we would develop what our plan would want to be. And our plan is whatever the court wants to be. And we would have to have input from the judges, would be probably the most format. I would envision that either me or Ken would be heavily involved in that, because really I think what we would want to do is see where our judges, see what plan, what programs, what they believe. Most every courts, and I'm going to go into a little more detail about mediation and how our judges do it. Most of our judges, if you have a contested civil case of any sort, whether it's a divorce case, a child custody case, a car wreck case, some other personal injury case, they're going to require, before you go to a jury trial, that you mediate the case. Mediations are highly successful in getting cases resolved, getting cases settled. And so courts here are typically going to refer cases to mediation. And they order that the respective parties pay their half of the mediation. What this would do is, in certain cases, if there were cases that those same judges now who are ordering mediation and ordering the parties to pay, they could refer those cases down to the county dispute resolution center, and then they would take over and have that case mediated, because you have the fees and the funds. Now, me standing here before you, where I see this be helpful would be in pro se cases, where you've got two pro se people that are, either suing each other or getting a divorce, and the judges want to order mediation, but the parties say, well, we don't have money to pay a mediator. Some of these mediators can charge $2,000 a party for a day's mediation. And if the judge orders it, then, and JD even mentioned that in his talk, that I can't remember what your words were, but sometimes they're higher than you think they should be, or higher than what you but that's the reality of it. And so you get pro se people who say, Judge, we can't afford the mediation. To me, those would be perfect cases for the judges to say, I'm going to refer this case over to our resolution center, and then the county would come in and pay for the mediator for those cases. Another area, and again, I say this without having talked to any of our justices of the peace, but recently they've increased the JP's limits from $10,000 to $20,000. So now your JPs are hearing matters or cases involving disputes of what I would consider a significant amount of money. I'm not sure that our JPs are utilizing mediation and ordering mediation, but if they are, because our justice courts are people courts, they're the courts of the people, and they're often dealing with pro se parties, to me that would be a great avenue to send JP court claims through the system. But that's a program that after we adopt and pass the resolution to create the program, then we have to figure out what we want our program to be, what the program would look like. As JD said, if we did nothing other than create the program today, the money that we're now sending to Austin would just stay here locally and just sit there until we did have a plan. It could sit there 5 years, and if we didn't have a plan, we wouldn't be spending any money because we have no plan, but we wouldn't be sending that money to Austin. It would sit here in our dispute resolution fund waiting for us to come up with a plan. But I do think we would want to get the judges involved in that. If I've done an okay job explaining that, I really think we're going to want to hear them and say, hey, where could you use this? Just so the court knows, at Judge McKinney's request, I did go up and meet with Judge Moore, our senior district judge, ran the program by him, and he has said that he gives it his blessing for court today and approves of it.
Who, you said they could send it down to the county resolution group?
Go ahead.
So he just kind of goes right into due diligence is necessary. We need to figure out, what he's suggesting. It could be one scenario, but it could be a scenario where, lawyers get appointed for cases, for criminal cases, mental health cases. They have to then go to purchasing to get paid. So, you could have a job posting in a sense of like, here are all the cases available to mediate, and have mediators come in, but this is how much you're getting paid. There's no racket. I feel like the people that hate hearing me the most are the mediators around town, because this affects the huge numbers that they're charging folks. But it could be a system that doesn't even mediate. You could use that money just to train folks in Henderson County to become mediators. You could say, our plan is to build a Henderson County Dispute Resolution Center and have county employees operate it. Well, that's going to cost millions. Well, we're going to need to save for 20 years for that. Regardless of the plan, it doesn't need to be in writing. This order, hopefully, y'all become the 10th county today. That doesn't have to go to the state, showing that you established a system. There's no reporting requirement. So in a back room, the commissioners could decide what's going on with the system, and it stays in that room. It's the Wild West. All the northern counties, they've had a system in place thanks to this guy named Carl Lucas out of Paris Junior College. They've been sending him cases. Every time he gets a case, he does it for $200. And I said, Carl, because they've kept hundreds of thousands of dollars. I said, Carl, they're not paying you enough. That's the extreme opposite end, but there's no contracts with Carl. There's nothing, but they just keep the money. So, yeah.
And nothing that, because it's the ultimately though, depending on what the plan is, it's those individual judges that would decide whether to refer a case to the plan, because we're not taking anything away from our sitting judge. Our judges would still be free to to send a case down to participate in the resolution center, or those judges would be free to continue to order the mediation as they did. I don't think this court can do anything to bind a district judge or even a county court at law judge on where they can send. It would be a tool for the judges, and that's why you would want to work with the judges. It's not a mandate to the judges. It's a tool for the judges. I just want to make sure that's clear.
Commissioner McCann, I would poll these judges. I would, along working with Clint, et cetera, figure out exactly what's going on and where things could be better used for. Maybe it's JPs, it could be, there's a lot that needs to be discovered, but what's the point of spending time and energy on due diligence when you don't have any money? I mean, so step one is, okay, let's start saving the money now, and JD, he'll, along with the other 9 Ed Cobb counties, is going to help us figure out what to do. It's that easy.
So when was this made into law?
January 1, 22.
And we're already collecting the money, we're just not keeping it.
Right. Yes, sir. It is literally a public service announcement, but just the word, believe it or not, didn't get here from Austin, how to keep your money.
Imagine that. So where are the 3 big counties at?
Smith is the only one that,
Well, I'm not talking about our region. I'm talking about across the state. Where's Dallas County? Harris County?
Dallas acted like they didn't even have the fund. They have a system. I asked how much money they kept, and they acted like they didn't know what it was. I didn't push it with that, but there's 193 counties, at least when I started looking at this in September, that hadn't established systems.
That had?
Had not.
Okay.
So my math, 254, 61 counties have established systems, but now plus 9, plus at least 70. But I don't know if maybe I missed the question.
I'm just saying, where's, Houston,
Yes, sir.
San Antonio, Dallas?
Bear County has a long system going. I just hadn't gone around and asked them all how much they've kept.
Well, I'm not talking about keeping. I'm talking about, do they have an ADR?
Oh, yeah.
Okay.
No, I mean, you should look at Bear County's website. I want to say it's probably one of the most well done as far as what their system does. It's all kinds of different things. It'll take a while to get to where you have a buffet of options like Bear County, but they've been in place since the ADR Act in '87.
And so has Harris County, and I'm not saying 87, but shortly thereafter.
Right.
Harris County, Houston has a very large active center. But again, the difference is in those counties is where JD said they're bringing in $3 million a year in mediation fees that can go into their system. We're going to be bringing in $32,000, and that's a very rough figure just based on last year. And if you're spending $1,000 per mediation, that's only 32 cases a year that you can send. And so, again, that's his point on we have time because you need to build that fund up, depending on how we use it, what the plan is, but you can definitely spend the money on it.
And we can set the fee that mediator would?
The center can, yes, because they'll be free to contract, just like our court-appointed attorneys. I mean, we can't make a mediator take that fee, but attorneys would be free to say, sure, I'll do it for that.
I feel like if
Mr. McMullen, our IT staff has asked if you'd move over to this side so that you can be seen.
Right here, just right here.
I like it. No.
Please continue.
I actually lost.
I'm sorry.
No, it wasn't anything too important. I mean, I'm just adding gravy to it now.
The action that's being requested here today is that we take this action to retain the funding.
Yes, sir.
That is what today's action is.
Yes, sir.
And from what I have heard, there is no timeline on when you have to have a program established.
Well, you officially have it established by issuing the order.
Well, then let me rephrase that. The administration and the administration of the program, there is no timeline
Correct.
in implementing that administration.
Correct.
allowing time for funds to grow and to develop out.
Yes, sir. And the very back of the first section has the proposed order, which, it lays that out there, that the order is being issued so the money can remain in the county for the research, development, and ultimate operation of the county's system. I mean, all the language that's in the order that I presented to y'all is the same language that is officially on the orders of 9 of your fellow county.
JD, can these funds be used for our DFPS cases, Department of Family and Protective Services cases?
I would say that's one of the better places, family type of cases, generally one of the better places to use it.
And those are fees right now that we're paying for mediators to come in. I'm not sure if the state sends us for those or not. I don't believe so, but I think we are paying to have those CPS cases, if you're not following the acronym world of DFPS. But that's all of our CPS cases where, again, you have a lot of mediations in those, and you have a lot of families that have an inability to pay for the mediator, which in that case, we're paying. I mean, you can come in and say, we're going to start it and do it on DFPS cases and pay the mediator.
All that you're given in Chapter 154 of the Civil Practice and Remedies Code are guidelines. There are no requirements for what a system is supposed to look like. If it does something to help resolve a dispute, it qualifies.
And we won't be doing this alone. As you can see from the list of counties that he read off, there was not a county in this entire EDCOG region that had implemented this plan because nobody knew about it. And so JD has gone out and solicited the 13. Is there 13?
Well, not solicited. I've been bugging and annoying them with emails and things like that.
And so we would be the 10th to sign up.
When we see where the need, you mentioned the CPS cases, you've mentioned the pro se civil cases at the JP level. We can see where the possible need is there. My concern is that once it's established, the funding side of it, the growth of that then outstrips the income of it, of which we are then putting other funds in to pay for. That's one of my concerns, not with today's action, but down the road.
I had that thought also.
Yeah. So,
Whenever you run, just like what he's talking about, when you run out of money, does the judge just quit putting them in there?
You order the termination of the system whenever you want. That's your parachute. And then you just give the money back. Whatever's left, I guess.
No, I'm talking about the $32,000. If they cost us $1,000 a piece, you got 32 of them. But when we get through with them 32, are the judges then informed that there's no money left in remediation? And so no other cases can be sent there, or what? So we don't have to put money out of another fund into it.
You're not required to, and legally you're not required to in any way, shape, or form. JD is 100% correct there. The problem you get into is as we all know, there are certain things that are easier on the legal side than they are on the practical applicability side. And if you got into a system and a program that where you've traditionally been doing this for all of these cases and all of these cases and just using that very loose math that I've given you and you recited back, and I'm the 33rd person that can't afford my mediation comes forward, that's where it would be problematic from the court's side. And the way you protect against that, again, this suggestion would be the way we protect against that is by doing our due diligence when we create the plan to make sure that our plan is capable of operating within its financial limits. And so we don't extend ourselves out there too far. We don't open it up to so many cases that the judges can refer over. We start out with a very limited scope. You can readdress that the next year, 5 years down the road. If you look back and say, gosh, we're sitting on a surplus of money because we're collecting way more than we're spending, then you start expanding the plan. But I think you would want to go into it with a fairly limited scope initially.
But if we go into it now, we can collect for the last quarter
you keep what's in there for the fourth quarter.
for the fourth quarter. And then next year, we'd start collecting. And to get all this information from all the judges and all the JPs and all that kind of stuff may take a couple of years to get the plan ready. So by then, you got $65,000 or $70,000 saved up. Because there's no time limit on how long it takes to get the plan ready for us to start implementing it. It's just that we're keeping the money to go back toward that plan.
And as to the certain number, so let's say you say 2 years. I mean, you could have, let's say, let's use it 100 mediations, all right? It depends on whatever. It could be half day mediations, full day. Every year, okay, the Commissioner's Court says this is the number we have. So judges, you're allotted this many cases that you want to refer to the system. And if this judge doesn't use all of their allocations, then a JP uses those allocations. It's there as a support system. It's not to take over the judicial aspect of it. But no, I mean, I do not want to come here and bring y'all more work to do, or, you know, I wouldn't be driving around saying, hey, I want to do something. I want to come around and annoy y'all with extra work. I'm trying to help y'all with no work.
So the other 9 counties in EDCOG, they're like us. They knew nothing about this program.
Correct. I just was familiar with it because in 22, I was down in Missouri County helping them with the same thing. And so when I moved back, it's like Greg and Henderson County, that's where all my people are, didn't have it. And then they were just like, well, there's, you know what EDCOG is. Pretty much I would go talk to any county who wants to listen about this.
Is there a percent that we have to give to EDCOG? I see they're
No.
not there a lot.
No, so I just put that as an example of them acting as administrator of the system. You could get EDCOG doesn't have to be a part of anything. And my understanding with EDCOG, and you know, y'all up here probably know better, is they have free staffing available. Like they could help with staff and be coordinating with the courts, the parties, et cetera. But that would be the extent of administration. But nothing with EDCOG. I mean,
EDCOG's simply a cooperative of the counties. If the counties were to agree to use EDCOG as an administrator, we could come up with an agreement between the counties, between EDCOG, and from what JD's represented, it sounds like EDCOG would be willing to do that.
but I don't know if all the counties, I don't think Gregg County, I think they might want to just have, they already kind of have a mediation will that I think they might just want to supplement. But I'm going to be advising them, just like the others. I feel like it's too early for any county to say this is exactly how our system's going to be.
And again, the action here today is to retain that money so that it is not sent to the state. I compare it to the 911 system. If we did not have our own 911 district, those funds, those fees that they collect on your phone bill would be sent to Austin and then returned to basically the COG, because when do not have your own district, the COG handles the 911 for our area. So it's a way of retaining funding today. I want to bring Ms. Monk into this, given it is the financial and any concerns, not at all.
You said something about 10 years. Is that in the resolution, or it's just established?
10 years, I mean, that's your discretion.
I think when he mentioned 10 years, I think he was just, again, throwing that out there that if you did nothing else other than 10 years, you could wait 10 years. We've also interchanged, 5 years, 2 years.
Okay.
Yeah.
Once we create it, once we start retaining the funds, we have an indefinite timeline as to when we spend those, if we spend those, how we spend those.
I do have one question. The interest earned on these funds, does it stay with the fund, or?
That's above my pay grade, but my understanding, talking to some treasurers and other places, they see it as interest bearing.
Well, from the resolution here stating that 75 to 80% of the cases that go to alternative dispute resolution come out with a settlement, which is in of itself a cost savings in the administration of the judicial process to the county.
And he touched on something that I had not thought about. We do not have very many local mediators. Most of our mediators on our cases are outside of Henderson County. And again, there's another avenue. I believe it's you would know this, a 40-hour
Yeah, and
one-week course to become a certified mediator.
plus the extra 30 for family law.
So 2 weeks.
Costs about $2,000.
So a lot of attorneys, we have a shortage of attorneys here in our county. We don't have many certified mediators.
You don't have to be a lawyer to be a mediator. So it could give people a second career path.
Court, further discussion on this? We are running close on time with our long
I
agenda
apologize.
today. Not at all.
I'll make the motion to approve the resolution.
Second.
Have a motion by Commissioner McCam, second by Commissioner Tooley, to approve the resolution and order of the Commissioners Court of Henderson
Hey,
County in
Judge.
support of the establishment of a civil court alternative dispute resolution system. Court, further discussion or comments? If not, all those in favor? Passes unanimously. Thank you, sir.
Judge, would it be possible to get a picture?
Given our lengthy
Hey, no, I
time,
didn't expect to take.
we had a Christmas picture we can give you that was taken today.
I put myself
Thank you. Item number 5. Item number 5, consider and take action on resolution adopting Section 775.0422 of the Texas Health and Safety Code. Court, this is the resolution, one of the issues we discussed in last week's workshop. What resolution, this resolution adopting this section authorizes, gives the Commissioners Court more ability to ensure the statutory responsibilities of the ESDs. We discussed this at great length last week, and this is one of those items of which that we discussed having on the court today. Be happy to answer any questions that you might have on it or concerns. This is our opportunity.
Is this rule in the Health and Safety Code?
It is.
77? If it's in the Health and Safety Code, why does the Commissioners Court have to approve it?
In this code, it says Commissioners Court, must adopt this resolution for it to be in effect.
So it's a law, but we have to adopt it to make it usable.
Yes. Mr. Strom, would you fill in the legal side of it a little more eloquently than I can?
Good morning, Court. Thank you. Yes, Commissioner McCown, under Section 775.042 of the Health Code, this particular statute, the ability of this court to remove an appointed ESD board member cannot be done unless the Commissioners Court adopts this section by resolution. So for it to become enforceable, it has to be adopted. And this gives the court a great tool in oversight for that type of board member.
And in the removal through this, it takes the whole court?
It takes a vote of the majority.
And this never was done prior to when the first ESDs were formed?
No, sir. It has never been enacted upon by Commissioners Court. And it allows for 3 authorizations. I'm sorry, I lost the name of the code, but 87.01 for misconduct and official misconduct.
It's the removal statute, and so that allows this court to remove for 3 reasons: incompetency, official misconduct, and misconduct. And those all have special definitions. And this isn't the exclusive remedy. There's also ways you can petition through a civil petition through the district court, through the county attorney's office, or seek criminal charges through the penal code under Chapter 39. Those are separate remedies, but this gives this court an exclusive remedy, and it gives it a different burden of proof. And so this would be a show cause burden of proof, where the other ones are beyond a reasonable doubt in the criminal and a preponderance in the civil. So.
It also, in the statute, gives us the ability of the 6 hours of CEUs that are required, that by adopting this, it allows that failure to obtain the 6 hours of CEUs that are statutorily required, it allows the failure to do that to be considered incompetence.
Correct, and that's statutorily provided. The rest of it's just by definition, but I think failure to do your duties as a board member would fall under incompetence as well. And so that would cover a lot of different scenarios. But that one in particular is statutory.
So is this a resolution that we have just overlooked?
A lot of the stuff in this chapter is automatic.
I've been on the court 8 years, and it hadn't been done. So, I mean, is this one that we just overlooked?
There's a lot of parts in this statute. I'm not sure why it wasn't adopted, but most of the parts in this chapter are automatic.
Yeah,
This one's
one.
not, and so it may have been overlooked. Or maybe it wasn't needed, maybe because it wasn't something that was looked into out of necessity, that it just wasn't looked into. So,
Quite honestly, since I've been on the court 26 years, the issue had been lightly discussed, but given the one small amount of tax money that they were collecting, the majority of them were volunteers, it was one that never really came to the point of the court that this is a serious matter, because you remember the majority of our emergency service districts were created and championed, I really should say championed more than created, by volunteers trying to do good work for the community. And so therefore, they're trying to help provide a service of which that the Commissioner's Court was reluctant to increase funding to. So they found a way around that. And first with your rural fire prevention districts. And then, of course, they all transitioned to emergency service districts following that. But given the amount, they are no longer these small organizations. There are a couple of them in there that are, but there are some. We have one now that will collect $1 million in the coming year. We have one as small as $75,000 in a year. But these are all matters, given that they are subdivisions of the state of Texas, just like ourselves as the county, school district, hospital board, and all of that. There are these requirements. And as it has, the amount of revenue collected in ad valorem tax will equal all of Road and Bridge of 2017. It's not small anymore. And it's that realization that really calls for the deep dive into the statutory responsibilities and options for the court. Because we have always felt, we're somewhat limited in our oversight. But through this deep dive, we have found that we're not quite as limited as what had been assumed.
I want to say, I don't have the number in front of me. You've had this tool since maybe around 2007, if not before. So you have had it for a while, but as Judge stated correctly, that in the last few years is when that tax base has really grown almost exponentially. It's just the last few years. So.
Questions? If there's no further questions on it, I'll wrap up by saying that will be over $4 million collected next year, or in 25 of ESDs. In 2021, that was 1.7 million, I believe. And when we talk about the exponential growth, this is a special district as defined by statute. Special districts have the fastest rate of growth in levies and tax levies and collections of revenues. Counties are at 18%, and special districts across the state are at 17% as far as total taxation paid. It is growing. It is the court's responsibility of fiscal oversight that we take these matters into hand, and I'll end it with that. We have the resolution to give the court the authority to be able to exercise oversight in a more efficient manner.
I think in the legislation this year, they've got a lot of stuff where they're going to bring up more stuff on MUDs and stuff too that's in the legislation. Yeah. Laws.
I'm going to be in support of it, but I think that we as a commissioners court is going to have to do because we're ones that appoint these people or ask these people to be appointed to these districts, and we're going to have to school them a little bit more or have some serious meetings with them and tell them what their job is going to be as an ESD commissioner, and because they're taking care of taxpayers' money, and we're the ones that are appointing them, and I don't think we do a due diligence. I know I don't. I try to tell them the top three things that they need to do. So I think that, if and when we do react this resolution, that we're going to have to spend some time educating them for the ones that we reappoint and appoint.
Anything further? If not, entertain a motion.
So move to approve.
I'll second the motion.
Motion made by Commissioner Tooley and second by Commissioner Richardson to approve the resolution adopting Section 775.0422 of the Texas Health and Safety Code as presented. Any further discussion? All those in favor? Passes unanimously. Thank you, Court. Item number 6 is consider and take action pursuant to Section 775.036A4 of the Texas Health and Safety Code, requesting a written report from the Henderson County Emergency Service Districts regarding their adopted 2024 budget, 2024 tax rate, and 2024 debt service. And as it is stated here, in number 4 of the first section of 775, upon a request from the Commissioner's Court, an ESD shall give a written report on the previous year's budget, tax rate, and debt service before February 1 of the following year. They must receive the letter prior to December 31 of the preceding year. So this year, it will be this December 31st that they must receive this letter to provide a written report on these 3 items to the court by February 1st of 2025.
And on that, that's only if we make a request that we want it.
Correct.
So we have to make the request each year to have it by that certain time. Because I remember one time when I was doing bringing the financial audit to the court to approve their financial audit or their exemption for it. I think I had their budget and all that too, and you told me at that time we didn't have to file their budget for filing or anything like that. But if we request it, then they have to.
Yes, sir.
Okay.
Yes, sir. And what we have prepared is a letter that is in your backup that is very straight to the point, asking those items pursuant to Section 775.036A4.
Will this be sent to every member of the board?
That that is what our desire is. Given the history where this court has sent out multiple letters since 2021, informing them of many of the responsibilities, and for some, we've gotten zero response from in 3 years. And taking this action, the previous action and this action, is specifically by statute and very, very clear.
I think it's a great idea to send it to all the board members so they'll all know what's going on.
But these letters are not stipulated to go to each board member, it's just to the district, is what these letters are stating.
It is to the district.
Right.
But they will be sent to all board members, because we previously had sent letters specifically to the presidents alone.
Okay.
And in 3 of our ESDs, there has been no compliance with what we've asked.
So ESD will get 5 letters sent.
Yes.
So to get all this information together, how long would that take?
That I do not know. I know
My only
that
question is, we send it December 31st, if they've already had their meeting, let's say this week. So they don't meet again till the 20th of January. That only leaves them a little 10 days.
true.
But as a financial person, these numbers they should already have easily. It's not going to take any research. They should know what their tax rate is. They should know what their debt is.
And their
The debt
budget.
service.
And their budget. They have all that.
They already have all that.
5 minutes.
This is separate and apart from the financial statement or audit.
Right.
This is just the report of those 3
They should have that handy.
elements.
It should be pretty simple to do.
And it's such a common duty if you go to the safety website on their posted calendar for the year, which is 1 page. It's bullet point number 3 that the ESDs need to submit that written report by February 1st.
We couldn't hear you.
Submit it by February 1st.
So are we only asking for the next coming year, or what they budgeted for this spring in their tax rate and stuff, or do we need it back for
It is for
3 years?
it is for their 24 year. The statute says the previous
year? Okay.
It's very limited. Any other questions or comments? Entertain a motion.
I'll make the motion.
I'll second the motion.
Motion made by Commissioner Spivey and seconded by Commissioner Richardson. I'm sorry, I want to make sure I get this right. To take action pursuant to Section 775.036A4 of the Texas Health and Safety Code, requesting written report from Henderson County Emergency Service Districts regarding their adopted 2024 budget, 2024 tax rate, and 2024 debt service. Any further discussion? All those in favor? Passes unanimously. Item 8, consider and take action to reappoint 2 members of the Emergency Service District Number 2 Board of Commissioners, Chet Martyr and Jody Vincic, for a 2-year term ending December 31, 2026. Commissioner?
Yes, Court. These 2 members have asked to be reappointed to the ESD number 2 that serves the Payne Springs Fire Department, Emergency Service District number 2.
Court, questions? I would like to point out, if I could please, and request that the president of the ESD2 board not be considered for reappointment. ESD2 is 3 years, a non-respondent to Section 775.082 of the Texas Health and Safety Code concerning their financials. And in the law, it states that, with some discussion about when you have that situation, the president and the treasurer are removed. There was much debate about if they are or if the court takes action. So in this time of reappointment, given the fact that that ESD has not met the statutory requirements of financial filings of a total of about $1 million in taxpayer funding, I would ask that the current president, Chet Marter, not be considered for reappointment.
So do you have information about all the other ones that we're reappointing this afternoon?
Yes, there is one other president in this list. The others, to my understanding, are members that are not either the president or the treasurer.
Well, once again, like I said before, I think that I know that there's a learning curve. He's been there for a while, but I really don't think he really knows what 775 or what we've requested. I've asked him, and there's been no teeth to it. And now that we have teeth, that if they don't respond now, that we have teeth to take care of them.
Court?
I think, it says we can remove the president and the treasurer. If he's the president, we can remove him from the president, and then he could be reappointed to the board as a member, but not as the president. So that's what we're to do by statute, is remove the president. And then, like I said, the president's a board member, but, right now, we know that needs to be reappointed, and he is the president. So if we need to remove him as president, then we probably don't need to reappoint him. But you could come back in the next deal for a replacement, and if you can't find another replacement and you want to reappoint him on the board, but not as the president, which the boards decide who's the president and who's the treasurer. Mm-hmm. The county doesn't. The commissioner's court doesn't do that. It's the board. So saying if you did reappoint him on December the 31st, come back and do it, I don't know if the board, we couldn't do anything about them putting him back as president. So that's just a discretion of who the commissioner's court wants to appoint. But it does say we're supposed to remove the president and the treasurer. But if we remove the president at this time or don't reappoint him, we still have the treasurer there that hasn't been removed too.
That's true. And that was a part of the discussion in the workshop, is that in our particular situation, I believe we have, let me find it here. ESD 2, ESD 4, and ESD 5, we have 3 ESDs that have not met the requirements of statute in 775082 or 821, which is for those that can file the sworn affidavit financials. And for 3 years, in 3 years, this court has begged and pleaded for these. And it comes to a grand total of $2.2 million that has not been reported on out of $4.7 million in the years 2021, 22, and 23. $1 million alone in this ESD. And that's why, since the trying again and again, I offer the court to this one. We can move forward, but I just want you to understand my reasoning.
And I believe that the treasurer that is at this ESD is not responsible for 21, 22, and 23, that she, maybe in January of 24 is her first, maybe actual, when she was elected to be the treasurer.
Well, in this place, I appointed Mr. Martyr 12 years ago when I was county commissioner.
I know you appointed him, I don't know how long ago it's been.
So it's the court's decision under this item.
Well, following the rules that we just set in place a few minutes ago, then we really don't have any choice but to remove him. But I think we've hamstrung ourselves to, maybe not down the road, but these guys, no matter that it went from 1.2 million to 4 million, these guys are still volunteers, and we fixing to have a hard time getting them. Because it's just like volunteer firemen. There used to be a lot of them. There ain't very many of them now because of all the rules and stipulations that the legislature's put on them. You know, all the classes they have to take, all the stuff that they have to do, all the equipment that you have to have. You know, who wants to volunteer anymore? So I think we're going to force ourselves into these ESDs fixing to be paid employees. That's up to them, you know, if that's what they want to do.
The legislation, they got it
But,
in
I mean, we fixing to,
on that now.
it's in the rules. We don't have no choice. I mean, it's wrote out in these 775 Health and Safety Code. Tells us what we have to do from the legislature. But we fixed to have a hard time. Because these guys are still volunteers. And I agree with Commissioner Tooley, we probably hadn't educated them enough. But you got to educate yourself too.
And we all swear an oath, the same oath, ESD commissioners, county judge, we swear the same oath to follow the laws of the state of Texas.
Well, they have an organization they can sign up with, just like we do with the Commissioners and Judges Association that we join. They've got one called SafeD that helps them guide themselves through all this stuff. And I know that several of our ASDs are not members of SafeD. Some of them are. And I think when you do sign up with them, you get the first year for free. Or something like that. A bunch of the stuff, they got a lot of stuff that's education and stuff that you can get from them. So,
Court, further discussion on the reappointments for ESD2? Hearing none, entertain a motion.
Judge, I move we reappoint Jody Vincic for Emergency Service District Number 2 with a term ending December 31st, 2026.
I'll second his motion.
Motion made by Commissioner Tooley and second by Commissioner Spivey to reappoint Jody Vincic for a 2-year term ending December 31, 2026. Any further discussion?
I'll be back on December 31st.
All those in favor? Passes unanimously. Item number 8, consider and take action to reappoint Ivory Givens, Charlotte Slayton, and Dr. J.D. Morton to the Henderson County Emergency Service District Number 7 Board of Commissioners for a term ending December 31, 2026. Commissioner?
Yes, this is Henderson County ESD number 7. They are in compliance, so I will recommend to reappoint all 3 members. I make that motion.
Do we have a second, or if again, I'm sorry, questions? Second?
I'll second the motion.
Motion made by Commissioner McCam and second by Commissioner Richardson to reappoint Ivory Gibbons, Charlotte Slayton, and Dr. J.D. Morton to the Henderson County Emergency Service District Number 7 Board of Commissioners for a term ending December 31, 2026. All those in favor of the motion? Passes unanimously. Item number 9, consider and take action to reappoint, and I'm going to be terrible with it, Carrie Barsano? Is that
Carrie Bersano.
Bersano to the Henderson County Emergency Service District Board 12 Board of Commissioners for a term ending December 31, 2026. Commissioner.
Yes, this is a new ESD 12. As far as we know, they are in compliance, and I move to reappoint Carrie Bersano to HCE ESD number 12.
Is there a second?
Second.
Motion by Commissioner McCam, second by Commissioner Tooley to reappoint Carrie Bersano to the Henderson County Emergency Service District 12 Board of Commissioners for a term ending December 31 of 2026. Further comment? All those in favor? Passes unanimously.
Who? Okay.
I'm sorry?
Who's the president on this now?
Branson. Item 10, consider and take action to reappoint Jake Branson and Rusty Quattlebaum to the Henderson County Emergency Service District Number 5 Board of Commissioners with a term ending December 1 of 2026. Commissioner?
I will follow the same steps as Commissioner number 2, and I will, Brownsboro is not in compliance, and I move that we reappoint Rusty Quattlebaum to HCSD number 5.
I'll second the motion.
Motion by Commissioner McCam, second by Commissioner Spivey to reappoint Rusty Quattlebaum to the Henderson County Emergency Service District Number 5 Board of Commissioners with a term ending December 1 of 2026. Court, are there questions, comments, or discussion? All those in favor of the motion? Passes unanimously. Item 11, consider and take action to reappoint Ernest Smith and Gary Dennis to Henderson County Emergency Service District Number 6 Board of Commissioners with a term ending December 31 of 2026. Commissioners?
Yes, this is ESD number 6. They are in Precinct 3 and Precinct 4. And they are in good standing. So I move that we reappoint Ernest Smith and Gary Dennis to HCSD 6 Board of Commissioners.
I'll second it.
Motion made by and second by Commissioner Richardson to reappoint Ernest Smith and Gary Dennis to Henderson County Emergency Service District Number 6 Board of Commissioners for a term ending December the 31st, 2026. Are there any questions, comments concerning this? Hearing none, all those in favor? Passes unanimously. Item 12, consider and take action to reappoint Jay Gravens and Howard Callaway to the Henderson County Emergency Service District Number 8 Board of Commissioners with a term ending December the 31st, 2026. I believe both commissioners share.
This is also comprised in Precinct 3 and Precinct 4. It is a new ESD, so they hadn't had, I believe this year will be the first year that they collect tax money. So next year will be the year when all their information will be due. And with that in mind, I move that we reappoint Jay Gravens and Howard Callaway to ESD number 8 Board of Commissioners.
I'll second the motion.
Motion by Commissioner McCam, second by Commissioner Richardson to reappoint Jay Gravens and Howard Callaway to the Henderson County Emergency Service District Number 8 Board of Commissioners with a term ending December 31 of 2026. Court, questions, discussion? Hearing none, all those in favor? Passes unanimously. Item 13, consider and take action to appoint 3 new members to the Emergency Service District Number 3 Board of Commissioners, being Darren Cheney, Philip McDaniel, and Kerry Howard for 2-year terms ending December 31, 2026. Commissioner?
Yes, Court. I've had 3 people that, one seek not to be reappointed, and 2 of them have retired. One spent 12 years. Joe Bergamy on the ESD, and then Larry Dunn was on there for 21 years for from the beginning of the existence of the ESD. And they've decided to pull away from it, so we've had to go out and recruit 3 new members for this ESD.
Court, questions? Hearing none, entertain a motion.
Make a motion to appoint to the Emergency Service District Number 3 Board of Commissioners Darren Cheney, Philip McDaniel, and Kerry Howard for a 2-year term ending December 31st of 2026.
I'll second the motion.
Motion made by Commissioner Richardson and second by Commissioner McCann to appoint 3 new members to the Emergency Service District Number 3 Board of Commissioners, being Darren Cheney, Philip McDaniel, and Kerry Howard for 2-year terms ending December 31 of 2026. Any further discussion?
And ESD 3 is in compliance.
Yes. All those in favor of the motion? Passes unanimously. Item 14, consider and take action to appoint 1 new member to the Emergency Service District Number 11 Board of Commissioners, Damon G. Donnell, for a 2-year term ending December 31, 2026. Commissioner?
Yes, Court. We had 1 member. His term was expiring, and he's actually moving out of the district to a new location, so he's not eligible anymore to be in Emergency Service District Number 11. So we are appointing a new member to the board, Damon G. Donnell, for a 2-year term ending December 31st, 2026.
Court, questions? Hearing none, entertain a motion.
I'd like to make a motion to appoint to Emergency Service District Number 11 Board of Commissioners Damon G. Donnell for a 2-year term ending December 31st of 2026.
I second the motion.
Motion made by Commissioner Richardson and second by Commissioner Spivey to appoint a new member to the Emergency Service District Number 11 Board of Commissioners, being Damon G. Donnell, for a 2-year term ending December 31 of 2026. Any further discussion?
And that, I do share that. Precinct 4 and Precinct 1 share that ESD together.
Any further comments? All those in favor? Passes unanimously. Item 15, consider and take action to reappoint 2 members to the Emergency Service District Number 11 Board of Commissioners for a 2-year term ending December 31 of 2026. And I'm sorry for the pause, Commissioner. Reappoint and new members.
Yeah,
I was seeing that. I probably said new members and not reading what was said.
Yeah,
It was
new
2
members, it's
reappointments.
members.
Yeah, my apologies. Commissioner?
we didn't get on the list on those, who those members were. Missed it, hang on.
So,
Let me get it right here. It's
Patrick Clark.
yeah, I've got it down here in the letter.
okay.
Yes, those 2 members there for ESD 11 that need to be reappointed is Patrick Clark and Michelle Stevenson, and they are in compliance, ESD 11.
Court, questions? If not, entertain a motion.
I'd like to make a motion to reappoint Pat Clark and Michelle Stevens to the ESD District Number 11 with a term ending December the 31st of 2026.
I'll second his motion.
Motion made by Commissioner Richardson and second by Commissioner Spivey to reappoint the two members, Pat Clark and Michelle Stevenson, to the Emergency Service District Number 11 Board of Commissioners for a 2-year term ending December 31 of 2026. Any further discussion? All those in favor of the motion? Passes unanimously. Thank you, Court. Item 16 is receive financial reports, of which there are none. Item 17, consider and take action on payroll distributions and accounts cash sheets, which we have none. Item 18 is consider and take action on submitted contracts, and we do have a couple of those. I will start as Mr. Vincent makes his way up with the elevator. It's a very simple contract. This is with the Elevated that does the elevator maintenance on all of our buildings. And in our current contract, it does not quote by board rates in that contract for repairs. Repairs, these buy board rates are typically 30 to 40% less than their standard repair costs. And this very simple contract addendum in which they saw us simply states that buy board rates apply. Questions? Hearing none, entertain a motion to approve with the judge's authorization to sign.
So moved with the judge's authorization to sign.
Second.
Motion made by Commissioner Richardson and second by Commissioner Tooley to approve the amended contract with Elevated as presented with the county judge's authorization to sign. All those in favor of the motion? Passes unanimously. The second item is with LumenServe and has to deal with our communications towers. Mr. Vincent.
Good morning. So LumenServe is a company that does tower lighting. We have 4 towers, obviously, not counting JCC. We have 4 towers that Henderson County owns. This came up because the lighting at the central tower, what we consider the legacy tower, needs to be updated to meet FAA and FCC compliances. We can do one of 2 things. We can replace the light or we can paint the tower. The lesser of the 2 options is replacing the light, which is approximately 25 years old. So LumenServe reached out to us while we were looking for a replacement light for Central. And what they offer is not only taking care of the lights, but also FAA reporting of any problems that we have. We have had some tower light issues at Crossroads and LaRue and Redbud. FAA requirements that if we have a tower light problem, we're supposed to have it reported within 30 minutes. There's a lot of other reporting and logbooks that are supposed to be done that we have not been doing, so this is going to resolve all of that.
Questions, Court?
And what these services include is $437 per tower,
Yes, sir.
and that's to do all of that?
That's to do everything. What they are going to do is they are going to replace the lights on all 4 towers, and they will do the reporting. There will be a monitoring system installed. They will report to us as well as the FAA. If there's a problem with the light, they call the tower climbers. They come out and they fix it. We are, other than the $400 and something a month, we are hands off.
And they'll keep up with, keep an eye on the lights to make sure when they go out, they
will put a
got a
device
monitor and.
at each tower site that will report. They have a network operations center in Austin that monitors 24 hours a day. They will do all the reporting to the FAA and keep us abreast of what's going on. They send out their tower climbers to fix any problems. Like I said, other than paying the monthly $400 and something a month per tower, we are hands off. And if you really go into the FAA guidelines, we're supposed to go look and physically put eyes on each tower every 24 hours and make sure the lights are working.
And so if we hire them, they're responsible for this, and if there's any fines that ever come, they wouldn't fine us, they'd fine them if we got a contract with them?
Yes, sir.
I would say that just because we have a contract, we are not released from penalties, but we do, by having a contract, it strengthens our position and allows us other avenues to proceed forward. Without the monitoring and meeting all of these, we have no excuse. We have no way of proving up our due diligence, so forth.
And with the personnel we have, it might be a couple weeks before you see a tire, or you might not even see it if you don't have trouble
Yes, sir.
at the tower. I mean, if you don't have trouble at the tower, probably don't go look at it.
I mean, if we
'Cause
were to
most of them are
actually,
out of the way.
if we were to actually lay eyes on all 4 towers every day, you're looking at a minimum of 2 hours a day, including weekends, to
I
drive
mean,
to all 4
two of
sites.
them are on the highway. Somebody probably drives by every day, but 2 of them are out in the country.
Yes, sir.
And
And we did have a problem at Crossroads one time, and we had Lieutenant Pokobratsky call me and say, hey, I didn't see the light on this morning. So, I mean, he lives out that way. But yes, LaRue and Redbud is a little more.
Remote. Budget is sufficient to
Yes, sir.
cover this?
Yes, sir.
this is the judge's signature.
I believe
Yes, sir.
so.
I'll make the motion with the judge's signature to author them.
I'll second the motion.
Motion by Commissioner McCann and second by Commissioner Richardson to approve the contract with Lumen Serve with the county judge's authorization to sign. Is there any further discussion or comment? If not, all those in favor of the motion? Passes unanimously.
Thank you.
Item 19, consider and take action on request for right-of-way permits. Commissioner?
Yes, Court, this is with Spectrum Charter for fiber cable around the 12,000 block of County Road 2803. It's a directional bore for 150 feet.
Is that the only one?
Yes, sir.
Okay. Court, questions? Entertain a motion.
I move we approve the proposed utility line activity for charter, or for Spectrum Charter for fiber cable at 12575 County Road 2803 for a 150-foot directional bore with the Commissioner's authorization to sign.
I'll second his motion.
Motion made by Commissioner Tooley and second by Commissioner Spivey to approve the right-of-way agreement with Spectrum Charter for the installation of fiber cable and a directional bore at 12575 County Road 2803 with the Commissioner's authorization to sign. Any further discussion? All those in favor? Passes unanimously. Item 20, consider and take action on submitted budget amendments, which we have. Item 21 is consider and take action on payment of bills. Ms. Carpenter.
Yes, sir, we have 2 sets today. Our first set is fiscal year 2024 in the amount of $421,666.70.
Commissioner Spivey, questions?
I did, but Ms. Monk answered it yesterday, and there's going to be a journal entry from her question.
Commissioner Tooley?
I have none.
Commissioner McCann?
I have none.
Commissioner Richardson?
No questions, Judge.
Entertain a motion.
I'd like to make a motion to approve the fiscal year 2024 bills in the amount of $441,666.70 as presented.
I'll second his motion.
Motion made by Commissioner Richardson and second by Commissioner Spivey to approve the 2024 bills in the amount of $441,666.70 as presented. Any further discussion? All those in favor? Passes unanimously. Ms. Carpenter?
We have fiscal year 2025 in the amount of $695,120.
Commissioner Spivey?
No questions, Judge.
Commissioner Tooley?
I have none.
Commissioner McCann?
None.
Commissioner Richardson?
No questions, Judge.
These are all our coming year
The
insurances and so forth. First quarter. Entertain a motion.
I'd like to make a motion to approve the fiscal year 2025 bills in the amount of $695,120.
I'll second his motion.
Motion made by Commissioner Richardson, second by Commissioner Spivey to approve the 2025 bills in the amount of $695,120. $120 as presented. All those in favor of the motion? Passes unanimously. Item 22, consider and take action on submitted plats.
No plats.
No plats. And item 23 is open and consider bids, which we have none. And then item 24 is to convene into executive session pursuant to Texas Government Code 551.074 to deliberate and discuss job applications and candidates for the position of Henderson County Fire Marshal and Precinct 2 Justice of the Peace. Court, can we have a motion to move into executive session and a time, please?
Make a motion to move into executive session at 10:40.
I'll second the motion.
Motion made by Commissioner Richardson and second by Commissioner McCam to move into executive session at 10:40. Further discussion? All those in favor? Passes unanimously. Okay, at this point, we're to item 25, which is a reconvene into open session. Can we have a motion to reconvene?
I'll make the motion to reconvene at
12:52.
12:52.
Second.
Motion made by Commissioner McCam and second by Commissioner Tooley to reconvene into open session at 12:52. All of those in favor of the motion? Passes unanimously. In item 25, it is to consider and take action on matters discussed in executive session. At this time, I do not believe, or court, is there any action we wish to take concerning discussed in executive session?
No action.
Our saga, our hunt continues. So at this time, since there is no action to take, we'll move to item 26, which is consider and take action to adjourn at 12:53.
So moved.
I'll second this motion.
Motion made by Commissioner Tooley and second by Commissioner Richardson to adjourn at 12:53. All those in favor? Passes unanimously. Thank you for being with